Now, I've been meaning to do this interview for a very long time. He's one of the best Palestinian legal scholars that we have. He's been a crucial voice all the way through the genocide. I'm one of many who's depended on his expertise. That's my cat walking past because he's so excited about the interview. This is the brilliant Nimer Sultany, who is as I say, a Palestinian legal scholar and also reader in public law at Suraj University, chief editor of the Palestine Yearbook of International Law. Many other also hats, which he's spinning on his head. Nimer, it's great to be able to speak to you and to talk. We're going to have a really interesting talk, I know, about the genocide, about the legal aspects of it, about angles which haven't been really touched upon, certainly in the mainstream media. So thanks for joining us. So it's a huge honor.
Thank you so much for having me and for the kind introduction.
I just want to start with that word genocide and the refusal, I suppose, of so many to use the word genocide, including some who will, I don't know, will perhaps rather performatively say critical things about the abomination which Israel is inflicting on the Palestinian people, and they won't even use abomination. I should be clear there. Kenneth Roth, the former executive director of Human Rights Watch, actually wrote a column this week about the reluctance to use the term genocide and gave his own reasons. Just as a legal scholar, I guess, what's your take on that? Why is there this reluctance? Some might, think of some obvious elements, but just what's your general take? Genocide and why there's that avoidance?
Well, I think we need to go back beyond the question of genocide to a kind of decades-long problem with the human rights discourse as well as in legal discourse, and more generally, obviously, in the political and the media discourse with respect to Israel, which is the lack of naming. We are told repeatedly when it comes to human rights advocacy that at least there is naming and shaming, even if there's no enforcement or actual accountability. But in the case of Israel, and in the case of the crimes that Israel has committed for decades in Palestine, there has been a reluctance to call a spade, not only with respect to genocide since October, but also with respect to apartheid for decades. So what we have seen a little bit of shift right before, like in the couple of years before the genocide, where suddenly, finally, Human Rights Watch and Amnesty International have released major reports, 500 pages, detailing why it should be called apartheid. But there is not much new factual and legal information that was detailed in these reports, which makes you wonder about the politics of naming, including by the leading human rights organizations. They could have said that 5 years before that, 10 years before that, 20 years before that, etc., because the facts were, even in these reports, they say it was established in 1948. And even when they did that, they decontextualized the apartheid, because apartheid historically is an associated practice of colonialism. So they said apartheid, but they did not say colonialism. They said, including Amnesty, that we will start from 1947, 1948 period. We're not going to talk about self-determination. So they wanted to avoid talking about Zionism as colonialism or settler colonialism. So this avoidance is continuous when it comes to Palestine, but it has been very jarring, specifically since October, because everyone with a phone and a conscience has seen every day since October what has been happening. And when you see, in the recent months, for example, someone like Miss Rachel, a provider or a producer of children's content, that is showing more courage than human rights lawyers or legal academics who should know better, it makes you wonder about the reasons for this delay. But in the case of the context in which the ICJ, the International Court of Justice, in three major orders called provisional measures in legal language, in January, March, and May, says explicitly that there is a risk of genocide. That should be enough to sound the alarm bells. And that should be enough for anyone to work for denouncing the genocide and preventing the genocide. Because the Genocide Convention is not only about punishing the perpetrators of genocide. International criminal law is not only about punishing the perpetrators of genocide, it's also about trying to prevent these atrocities. The reason we have mechanisms of international law and accountability is to try to deter crimes, to try to prevent them, or at least to stop them before they go any further. And the fact that we had a lot of sophistry around these three orders by the ICJ, and even after the ICC, finally there's a crack in the shield of impunity that Israel has been granted for decades. Still, we found many who preferred either to stay silent or to continue the propaganda for Israel, or to use sophistry to dismiss, to excuse, and to distract from actually attempting to stop Israel and punishing Israel for doing what has been doing. So the lack of naming of the crime of genocide in this case is related to this reluctance to hold Israel to account. Now, obviously, the main problem or the main distinctive marker of this particular genocide, that it is a Western genocide. It's a genocide by a self-styled European and Western state. It is armed to the teeth by the West. It considers itself as a European post in the Middle East or in Asia. And it is continuously supported before and after October with arms, with diplomacy, and with obviously media narratives and financial relations. So the other reason, I would say, for the reluctance is that there is a lot of people who are complicit, who were cheerleaders in this genocide. So all these academic institutions, all these media institutions, all these governments, all these political parties have no incentive to name the genocide, even after a couple of years of it happening in front of our eyes daily, because this means that they will recognize their own cowardice, their own complicity, their own obligations, including legal obligations on states, that they should have intervened earlier, because Western states in particular are the ones that have these contacts and possibility of influence over Israel. And they haven't used, not only they haven't used that, they also did the opposite, which is enable Israel and embolden Israel to continue in doing this genocide. And you would remember that when it comes to the comparison between Russian war crimes in Ukraine and Israeli war crimes, similar crimes, attacking hospitals, attacking children's hospitals, attacking, a siege that included no water, no electricity, etc. All these things happened in both cases. And many of these European leaders or the North American leaders were easily vocal when it comes to Russia, saying that these are war crimes and not waiting to any kind of legal authority or court to pronounce on these issues. But they declined to do the same with respect to Israel. And obviously, this leads to questions of selectivity, double standards, racism. Israel is a Western ally, while Russia is an enemy of the West.
One of the things, as somebody who isn't a legal scholar, always found slightly bewildering is, in terms of genocide denial, in the case of Israel's genocide against the Palestinian people in Gaza, is the argument put is that, well, genocide as a crime has a particularly high threshold, which is to do with intent. And that's normally the most difficult element, proving intent, rather than looking at genocidal actions and working backwards from there. And Raz Sigal, who, for those, I hope lots of people are familiar with him, he's an Israeli-American associate professor of genocide and Holocaust studies, who spoke about genocide very early on, days after 7th October. And he did that on the basis of intent. And he said it was actually extremely rare for a state to be so open about its intent. Normally states committing terrible crimes, including genocide, go to huge lengths to suppress their intent. And that, I think, speaks to Israeli impunity. The fact they just keep saying it out loud is because they know they have impunity, so they don't fear any consequences. What do you think about that? I mean, it's just, in fact, you corrected me quite rightly the other day, because I wrote an article for The Guardian where I noted South Africa's submission about examples of genocidal intent from last year, which ran to over 130 pages or so. And you said there was a more up-to-date version this year, which was about 220 pages. What do you think about that? I just find it bewildering. Surely actually the intent part seems to me the easiest part almost to prove, because it's just so explicit.
Indeed, this is, I think, as an example of the sophistry or the propaganda in some cases on behalf of Israel. Because when it comes to legal discourse, in addition to Ras Segal, in the mid of October, or 15th, I think, or the 17th of October, hundreds of legal scholars signed a letter warning of genocide. So there was a lot of, and many UN experts as well, around, in October and November, were also warning of genocide. And they were pointing to the daily production of Israeli genocidal statements on Israeli radio, on Israeli websites, on Israeli TV channels, on Israeli soldiers' Instagram and other social media platforms, etc. But what we have seen with respect to legal discourse is, for a long time, there was a focus on the kind of individual violations of the law, the more technical and depoliticized discussions of international law. So, for example, a discussion of proportionality of a particular strike in Jabalia. So legal scholars are much more, in their elements when it comes to these depoliticized and technical discussions, because they don't want to talk about the context. So for a long time, they ignored all these genocidal statements. And the media, as you know, also ignore these genocidal statements.
Yeah, it's really important that people know that they either buried them without explaining their implications, or they just did not cover them at all. And I've gone through lots of those genocidal statements and done searches for their coverage in media outlets, and they generally were not covered at all.
Yeah, and I think one of the benefits actually of the genocide case brought by South Africa and the ruling in January is that it finally pushed some of the media to start mentioning some of these statements. Yeah. Now, what we see recently, I think, is that there's an emphasis on statements by Smotrich and Ben-Gvir and all these people now. And many of those who are recently going out and saying this is a genocide are pointing out to these statements. But if you look at the record, they have been saying the same thing repeatedly, they and others, obviously, since October and November and December 2023. So there is nothing much new in these statements. But what we saw from many including legal scholars, is that this attempt to dismiss these statements as if Smotrich and Ben-Gvir, for example, are not important, while now everyone knows and should acknowledge that Benjamin Netanyahu's survival and continuing to be in government is because of the support of these people. And we have seen in New York Times, recently, kind of an article showing that this support was crucial for the continuation of the genocide. So to dismiss these statements and to try to say that, the president of Israel, when he says there are no civilians, the whole nation is responsible and there will be collective punishment, to dismiss all these statements is not only to hide the fact of genocide, but also, I think, ignores the fact that what happened, I think you and others have called the genocidal mania, is that in Israel, what happened is that there is a consensus that we can call the genocidal consensus. The fact that these statements are repeated by singers, by soldiers, by commanders, by journalists, by politicians, again and again and again for
random members of the public. Random members of the public. I mean, it's the classic. You see a tweet in Hebrew and press translate, and you take the brace position very quickly.
Yeah, so this means that there is a kind of the public discourse is shaped by this genocidal mentality, by this. So genocidal intent is not only these few individuals that we can cite, but also the fact that they produced public opinion makers. They produced the consensus that not only allows for the continuation of the incitement to genocide in violation of the ICJ orders, but also prevents any attempt by the Israeli legal system, even if there's like a couple of good guys there who want to hold to account some of these inciters to genocide or rapists of prisoners in Sdei Timan, that becomes difficult to do because of this public pressure and this continuous public support for genocide for over 650 days. So that also leads to another question that I think is relevant to your question about this intent. So recently, we have heard from a very prominent human rights lawyer in this country, very esteemed one, and she said for 2 months before that she was reluctant to say genocide, and she opposed to the casual use of the word genocide. And a couple of weeks ago, she said, we are witnessing now genocide, and that she was reluctant because we need a special intent, and the threshold is high. Now, for me, this is puzzling for different reasons. First of all, in the December 2024, two major human rights organizations, Amnesty International and then Human Rights Watch, and on different grounds, produced 500 pages of documentation and analysis and reached a conclusion that this is genocide. Even in the same month, even the pro-Israeli organization called Genocide Watch also said on different grounds that this is a genocide. So already in December, we can say, at least since that point, we have a consensus that there is a genocide. And then this famous human rights lawyer says that she thinks that only now this high threshold and this special intent has been met. So what does that mean? This, obviously, for me, an attempt to explain the prolonged silence, the delay in naming the genocide. But it's puzzling for the following reason. So if you are a human rights lawyer or a legal kind of advocate, and you want to submit to the ICC or the ICJ or any, or even write an academic article on genocide, you will cite and quote the main authorities on genocide international law. And one of these main authorities is William Schabas, who wrote a 900-page book in the second edition. There's a third edition, actually, I haven't seen it yet. So these guys, people like William Schabas and another author of a book on genocide international law, a textbook by John Quigley, have said it over a year and a half ago. And they are well aware of the high threshold. They are well aware of special intent, but they said it publicly a while back. So esteemed human rights lawyer in this country could have said it earlier. They chose not to say it earlier. And they could have used their own esteem to actually influence public opinion, influence newspapers, influence even government and parliamentarians. They chose not to do so. And it's unfortunate that they have chosen to do so.
And that accountability is very much part of the reckoning that must take place. You mentioned South Africa.
In terms of, sorry to interrupt you, but we can add also here that what's embarrassing, I think, to many of these kind of legal advocates, as well as governments, Western governments, is that as the genocide has progressed in Gaza, in November, 6 Western countries, including the UK, Germany, and France, and the Netherlands, and Canada, submitted what we call, an intervention in the ICJ case, the International Court of Justice case of the Gambia versus Myanmar, with respect to the genocide against the Rohingya. And in that submission, it's marvelous to see, because they had now basically to backtrack what they said. They said, in interpreting the Genocide Convention, the court should have a balanced approach and not to have the bar too high. And one of the examples they mentioned is the question of killing children. So they said, if there is a significant number of children who are being killed, maimed, or psychologically harmed, this in itself discounts any military or security justification. And this is an indication of genocidal intent. So if you compare, and I have read in, I think, February 2024, an article by in Forbes magazine by a legal scholar who said that 623 children killed in Ukraine and over 2,000 who were injured is an indication of a genocidal act on the part of Russia.
Yep.
We are now in a situation where we have at least 17,000 children, Palestinian children, who were killed. More than 20,000 orphaned, more than 22,000 amputated, not to mention the psychological harm to a generation of Palestinian children. We're talking about hundreds of thousands of children and the destruction of their schools and their future. And yet, these same scholars do not come up and step up basically and say this is a genocide by virtue of this killing. Remember, again, there is not much new in this information. By the end of October 2023 and the beginning of November 2023, the UN has already been saying this is a war on children. This is a war on childhood, and that Gaza is becoming a graveyard for children. And Save the Children also said, I think, in the same period that the number of children being killed in October and November is more than the 3-4 years combined of conflicts around the world. And Oxfam was saying that by the end of October, that Israel is using starvation as a method of warfare. So when you see many now saying that this is genocide now and talking about genocide now, they need to be confronted by the fact that much of these facts have been repeatedly shown, and much of this genocidal intent has repeatedly and actually unprecedentedly in the history of legal debates and public debates about genocide. It's very hard, I think, to find a case in which genocidal intent has been so clear, so vocal, and so in your face. And yet we have human rights lawyers and legal and scholars and politicians and newspapers who come up with the epiphany in July 2025 and tell us that it has been this is genocide. And of course, they won't say that it was a genocide in November 2023 because they need to explain their silence all over this period. So they do what I call a revisionist account. They claim it's only now a genocide. Since March or May 2025, it was a war that evolved into a genocide. And this is, again, cowardly and not convincing at all.
I mean, the reason I just find it so farcical is on the 9th of October 2023, I wrote about Gallant's declaration about human animals. We're fighting human animals in the siege imposed on Palestinian people. I tweeted it was genocidal language because it was so obvious. It didn't take any insight. It didn't take any expertise. It was...
but also what's infuriating in the media treatment, what is really outrageous, is that even now you would see people say, well, all these comments by the Israelis were hyperbole. They were just, furious comments because of the shock of October, etc. And even if we assumed that was correct in October or November or December, how do you explain the rest of it? All these months since then, 655 days of these events. And secondly, the kind of double standards, which is they would never grant the benefit of the doubt to a Palestinian. Any Palestinian who says anything will be an eternal proof of Palestinian intent.
Exactly. Even if the whole family had just been exterminated, for example. But you're right. I mean, in October 2023, Air Wars, the NGO, obviously, as they showed what we all saw at the time, actually, which was the mass extermination from the air and the obliteration of Gaza, which was a different colour and texture when looked at from space by the end of 2023. There was no excuses there at all. You mentioned, obviously, South Africa's case at the International Court of Justice, the highest court on earth, the UN court, alleging what Israel is obviously guilty of, genocide. But I'm saying in the context, they put forward in the legal system that as a charge. I mean, some are very cynical about the international legal order because they would say, well, this is rigged in favour of the old colonial powers of the global north. That's basically what it exists to do, and they accordingly pick and choose. You can't you can't use the master's tools to end slavery. Something along those terms. You probably know the phrase. What do you think about that? You kind of, well, is this just basically a waste of time? You can't subvert a system used to protect the likes of the US and Israel. You can't subvert that system to hold them to account.
Well, I think we need to distinguish between two kinds of questions. One question is, in a particular concrete historical context, how do you use the law? What role does this law play? And then there's another question, which is, if you are aiming for liberation and freedom, would law be the main or primary or the exclusive tool for that liberation? So these are two questions, different questions. So we can answer the second question negatively. Law is not and does not allow you to escape from politics, because law itself is intertwined with politics. It itself is a means for political contestation. It is a field where competing parties try to achieve their ends. And sometimes the asymmetry of power outside the courtroom is reproduced in legal discourse and in the courtroom. But the first question is the more important question at this particular moment, which is, what do you do as an ethical agent now when you see the suffering? So the question, the slogan, the master's tools do not, you can't dismantle the master's house with the master's tools, does not answer the ethical question of, if you are a lawyer for South Africa, what do you do? Do you go the ICJ and try to do something? And for me as a Palestinian, I think the colonialism should be struggled against and fought in all fields of social action, including the legal field. So in this sense, I saw the action by South Africa as an anti-colonial action against this biased Western system. And I called it in January as an epic battle between the global North and the global South, because what we have seen now is that finally there is a contestation of exactly what you mentioned, which is the lopsided nature of the international legal system, and the fact, including the fact that it allowed Israel to be emboldened to do what it has been doing for decades, but more recently and more grievously since October, obviously. So you need to contest in these fields. But now, in order to, I think the disillusionment and the disenchantment with law is obviously justified, because the legal system was not effective, did not lead so far to kind of actual tangible results. But if you go back to the moment in which South Africa submitted its application in the end of December, and then when the court issued its first ruling in January, what was the situation of the public debate in the media? What was the situation in the UN Security Council? So if you compare the legal field and what the ICJ eventually did in January, you see it's completely and entirely justified to use the legal field, because it was much better than all these fields combined. It was much more of a rational discussion than we have seen in all these fields. And it cracked the wall-to-wall support, the Western wall-to-wall support in the media and in government because of the application itself and then the ICJ ruling itself. So in terms of legal discourse, this was a leap in terms of the treatment of Palestine. Historically, Palestine has been, from a legal perspective, analyzed only from the perspective of, or mainly from the perspective of international humanitarian law, which includes the laws of armed conflict, but also occupation law. And the focus was always about, particular and concrete and disparate violations of the law rather than context. And then the first leap in legal discourse was the apartheid discussion, or reports by Amnesty and Human Rights Watch in particular, which were ignored by European governments and most of the media, even as a context for what happened on October 7th and its aftermath. And that's because there was a search by human rights organizations for a context or a more comprehensive account of what is happening in Palestine. What are the different methods of oppression and subordination and discrimination and exclusion and brutalization that Israel has used towards different Palestinian communities, whether they are the refugees in the West Bank, in Gaza, in East Jerusalem, or the Palestinians who are citizens inside Israel, 20% or so of the population. So you want a comprehensive narrative. And the apartheid reports provided the first leap in legal discourse. And then the genocide case. Again, in terms of what was happening in the media and even in academia, and obviously by governmental formal statements, there was no context or a comprehensive account of what Israel has been doing. Sometimes there was some lip service of telling Israel to abide by international law and not to violate international law in particular cases, but there was no comprehensive account or word for what Israel has been inflicting on the Palestinians since October. And genocide is the word. And what we talked about in terms of avoiding or ignoring genocidal intent was part of this avoidance. And then thirdly, another leap, I think, in terms of the legal treatment was the ICC, the International Criminal Court, issuing arrest warrants. So for a couple of decades, the ICC has been marred by the difficulties and the criticism that it's only focusing on Africans. And we saw that Karim Khan was told as much by some American officials that, keep it this way. And you can add Putin and all these people, but not...
Yeah, it looks like Putin and Africa. That's what he said. That's what he was told.
And finally, there's a crack. Now, the crack in the shield of impunity, when the ICC issued these arrest warrants, it's not sufficient. We should see more. It was a bit limited on some aspects, but at least for the first time, there is these. Now, the effect of legal discourse in this case is also twofold. One, if you remember how much journalists and students and academics who were talking about Israel's, extreme depravity in this campaign, genocidal campaign against Gaza, they were attacked, they were arrested, they were, in the media were demonized, and then suddenly, and of course, the previous, Secretary of State in the UK and others who were attacking the so-called hate marches that the Palestinian Solidarity Campaign and others were organizing in London. And suddenly you have the ICJ telling these students that you are right to be alarmed, telling these journalists that you are right to be alarmed. And it emboldened, if anything, it emboldened these anti-war protests in London and elsewhere. So even though the legal field itself so far did not produce tangible results, it actually produced a change in the discourse, public discourse, and it produced some form of support for students and other anti-war movements and mobilizations.
A couple of other things I wanted to ask. One was about a couple of Israeli lawyers, and a lawyer and a judge. There's Eyal Ben-Benisti, who was selected by Israel to defend itself from accusations, obviously justified accusations of genocide by South Africa at the International Court of Justice, when the Israeli state has said it will build a concentration camp, which will then be used to remove the survivors of Gaza altogether. So no living human beings live in Gaza. Anyone who refuses to be placed in this concentration camp will be murdered, exterminated, regarded as a legitimate military target. He then co-wrote a piece which said that this would be a war crime and a crime against humanity, and then subsequently signed a letter which suggests it could be an act of genocide. I'm also interested in the Justice Aaron Barak, who is the Israeli ad hoc judge on the International Court of Justice, obviously largely. I think it's interesting, by the way, with him, because obviously he sided with Israel's case throughout, except he did support the provisional order compelling Israel to take action against the public and direct incitement of genocide, which is, of course, one of the 5 crimes listed in the Genocide Convention of 1948, which the provisional order demanded Israel abide by, and it clearly hasn't. I'm just interested in those 2 examples. I'm just interested with it because, there was no coverage of that. Eyal Ben-Benisti, you can kind of think the fact that an Israeli lawyer who defended Israel against the charge of genocide and was selected to do that is now suggesting that Israel could end up. He's not saying they're committing genocide now, but I'm not giving him any credit, by the way. What do you think about these 2 examples? What would you say about them?
Yeah, the first thing to note, as you just said, that it's very hard to find even a single, there is one actually that I have in mind, Israeli legal scholar who said genocide. But other than that, many of the Israeli legal scholars and Israeli jurists are still in the mode of genocide denial. Yeah. I think one of the things that explains, the reaction of many, including Eyal Ben-Benisti and Aaron Barak, is there was a sense of national patriotism, you might call it, after October, the state is under attack. There's the kind of false propaganda of calling it an existential war. And the two names you mentioned are what we can call the best you can get in Israel. So these are progressive lawyers, human rights-minded lawyers, to the left of the center, and they are ones who are concerned with, legality and the rule of law inside Israel itself. But yet, because of this misconceived and misguided sense of patriotism, they played a role in the propaganda for the Israeli state. Eyal Ben-Venusti as becoming a lawyer or one of the lawyers for Israel in the case itself. And Aharon Barak was appointed by Netanyahu. Now, Aharon Barak, I think, is an interesting case because Aharon Barak, who was one of the most famous judges in the history of Israel and the former Chief Justice of Israel, has played a similar role previously. So in 2004, when the ICJ, the International Court of Justice, was about to deliver its ruling on the wall, the apartheid wall that Israel constructed in the West Bank, Ariel Sharon was the prime minister at the time. And he said that Aharon Barak and the Supreme Court in Israel, or the High Court of Justice, will be a shield, will act as a shield for Israel. Now, this is interesting because Aharon Barak is one of those who are responsible for the fact that Ariel Sharon was expelled from the political sphere for a couple of decades because of his role in the commission on the Sabra and Shatila massacre, where they blamed Ariel Sharon for some of these massacres. So despite that, Ariel Sharon, the right-wing politician and extreme military leader, recognized the value of someone like Aharon Barak and the willingness of Aharon Barak to play that role. Now, fast forward 20 years later, Benjamin Netanyahu, again, there is no love between these two, recognized the value of Aharon Barak, and Aharon Barak was voluntarily willing to play this role of a defender of the most extreme government in the history of Israel. Now, so these two jurists that you mentioned are well aware of the fact that this is the most extreme government in the history of Israel. They're well aware of the fact that Smotrich and Ben-Gvir are in this government. They're well aware of the fact that, newspapers like Haaretz has been writing about what it called the Kahanization of the Israeli police force, for example, because a reference to Kahana, who is a racist and a fascist Israeli Jewish leader, who also was kind of at some point expelled from the Knesset because of his racism. So now we have these people, his supporters of Kahana, are in government, and yet these two jurists, these two esteemed, progressive, seemingly rational jurists, are willing to play the role of propaganda, of shielding Israel. And shielding Israel in this case means prolonging the genocide.
Yeah,
it means more people will be killed.
Exactly.
So suddenly, a year later, now they're talking about concentration camps as ethnic cleansing, as a war crime. You need to disobey. This is a welcome development, but it does not excuse their behavior previously. And remember that Aharon Barak used the ICJ as a platform to basically disseminate Israeli propaganda. So he said, for example, in early on and repeatedly, that this is an existential war. But if you compare his statements as a judge to what Ehud Barak, a former Minister of Defense, a former Prime Minister in Israel, said in October and November, and three other former heads of the Mossad and the Shabak, the Internal Intelligence Service, as well as the director of the military intelligence during that period. All of them said it's not an existential war. The gross of asymmetry of power is very clear, and there is no danger for the state. This is not a second independence war. This is only Netanyahu propaganda. And yet this liberal judge goes to the ICJ and makes these propaganda claims in the court. So I think, and then egregiously, Ben-Venusti, and in some earlier comments like a year ago, he said something like that this claim that Israel is committing genocide is a kind of a psychological or subjective feeling of the Palestinians rather than a factual and a legal claim. Again, trying to dismiss, excuse, ridicule claims of genocide. And these people remained silent when Amnesty International and Human Rights Watch and many others have said it's a genocide. So, and remember also, it's not about genocide. It's about the role they play. Again, I call it the legitimation, role of legitimation for Israel, which is including when the ICC was discussing in 2021 whether they have the jurisdiction to examine and investigate Israeli crimes in the West Bank and Gaza. Many Israeli jurists, including Eyal Ben-Venesti, submitted to the court intervention saying that it should rule that it does not have. So they were part of the shield of legitimacy. Aharon Barak, in his role as a Chief Justice, gave aura of rule of law and legitimation to the occupation, despite the fact that it became increasingly brutal and ruthless, despite the fact that it was clear it's becoming an annexation, not only occupation. So decent people around the world look at an esteemed judge like this, who is received well in North America in particular, and say, if this person can live with the occupation, we can live with the occupation. So I think one of the problems, and you can see it also in the ICC prosecutor, Karim Khan, in one of his first reactions, I think when he went to Rafah, and he said something along the lines that Israel has great lawyers. 10 years before that, the founder prosecutor of the ICC, Ocampo, said the same thing. After he left office in 2014, he went to Israel. He said, "You have nothing to fear of the Intersectional Court. You are a rule of law country, and you have great lawyers." So this false image, this fiction that Israel has, because it's devoid of facts. Because the facts are there, all these reports and all these experiences that we have seen before October 2023, but also more so now, universally recognized after October, that the Israeli legal system and judicial system exists to legitimate the occupation, to make it look less objectionable than it is. And by doing so, they allow these atrocities to continue and to happen. And it's time that this myth, that there is this kind of respectable Israeli Supreme Court, and that Israel has these, independently minded legal scholars who are activists and can, dispute what the government says, I think has to end, because we need to think now in terms of the actual realities. And I think one of the difficulties with many of these legal scholars is that their reputation is tied to the state. So what they fear is that if there's a recognition that Israel is a state, apartheid state, that has committed genocide, then their reputation will suffer some damage alongside the delegitimation of the Israeli legal and political system.
I mean, just quickly, lastly, that's what I was going to ask you, actually, which is, I often, from a media perspective, look at the role of my colleagues who are complicit in genocide. And we should be absolutely clear about that. My colleagues in the British media are complicit in genocide. And it would not be possible for Western governments to have armed and supported this genocide without the role of the Western media. It would have been completely impossible. And there has to be a reckoning. And I'm just wondering what you think about the reckoning with the legal establishment.
Yeah, I think, the atrocities that we have been seeing are really unprecedented in many ways. And obviously, many, not only in the media, as you said, but also in the academia generally, and legal academia in particular, did not rise to the challenge of the moment. It cannot be said that they actually met the challenge of these moments. And when you have all these academics who teach human rights, who teach free speech, who teach about the history of colonialism, and yet, or the history of freedom, or the history of democracy, and yet these same people remain silent when it comes to the suppression of free speech about Palestine in Western countries. or when they see an unfolding colonial apartheid and they remain silent about it, when they see a present-day genocide and they're not willing to denounce it, although they are more than willing to denounce past genocides. So obviously here, this ideal of the intellectual, the public intellectual that Edward Said and Noam Chomsky has written about. Noam Chomsky famously wrote an article on the responsibility of intellectuals during the Vietnam War. This ideal of the intellectual or the academic or the intervener in public debates, who speaks truth to power, who disputes prevailing norms, who's willing to challenge governments and official narratives, who's willing to highlight context and not focus on symptoms and go to the root causes, who is willing to name the thing, whether it's genocide or apartheid or the other atrocities and violations of the law. This ideal has been failed, has not been realized in many cases. And I think when you see the example that scholars and activists like Chomsky and Edward Said have set, that it's realistic to expect that some people will do that, despite the fact there are disciplinary, professional, financial, and the rest of it costs. And obviously the media played a disciplinary role because anyone who spoke up, whether students or academics, were attacked, including in this country. But I think we can expect from many to have spoken. That they haven't spoken, and they should have spoken about these atrocities as they are, happening. Mm-hmm. And the fact that many are speaking now, when the cost for speaking is marginal, again, it doesn't show any courage or any principles. As Rosa Luxemburg once said, the most revolutionary act in these moments is to speak up about what's happening, to say what's happening. And unfortunately, for 650 days, most of us, academics, legal scholars, media persons, parliamentarians, etc., have failed to speak up. And therefore, we are all, in a way, complicit in what has happened and the fact that Gaza is being now destroyed.
Well, certainly not you. You've used your voice consistently, and I have to say the emotional labour involved, I'm always aware of, being someone who's Palestinian, having to every single day speak out about the genocide of your own people in a country which is facilitating that genocide while you're being gaslit and fed relentless lies and smears by the media of this country and by politicians, is something which you have certainly my eternal solidarity in the people watching. I know that. You've been a brilliant and crucial voice. And that was such a, tour de force in terms of the legal position, unpicking some of those nuances, which I think were just so important for us to go into. So for everyone watching, do share, press like, subscribe, leave your comments, your thoughts. Love to hear your thoughts on this. Share the video, make sure everyone hears Nimer. But honestly, it's been such an honour. So thank you so much.
Thank you so much. And thank you all as well for being a vocal and outspoken critic of these atrocities and a defender of basic human rights. Thank you very much.
God bless you. Thank you.